This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we do have Todd Lutsky from Cushing & Dolan with us right now for Ask Todd. As always, it's your chance to ask Todd your estate planning questions. I'm sure some of them came up over the Thanksgiving dinner table, so the studio lines are open at 888-205-2263. We do have limited space on those phone lines, so do make sure that you call early to make sure that you can get your question answered by Todd. That number again is 888-205-2263, and we've got those lines open one more time at 888-205-2263. Mr. Lutsky, how are you today?
I am great. And you?
Doing well, but did you happen to see that Rudolph the Red-Nosed Reindeer just got his latest grades for the semester?
Grades?
Yeah.
No.
Went down in history.
That's true. He does.
Yeah, wasn't good. Let's talk a little bit about the estate tax. Todd, in terms of the federal estate tax thresholds right now, where do they currently stand, and how many families are typically impacted by the federal estate tax in a given year?
So it's a great question for now because there was an election that is going to impact the answer to that question, we believe. So currently the estate tax exemption is $13.6 million federally. So this is for everybody listening, right? Federally. Doesn't matter what state you're in, but we're going to have to address that separately. So $13.6 million, that means if you die and you leave assets more than $13.6 million to someone other than a spouse, then you have a tax problem. Now, to a spouse, remember, folks, it's unlimited, which is the trap for the unwary, right? Those are the people who say, I just leave everything to my spouse, and that's great, except it would cause the spouse to be poised to maybe pay more taxes when the spouse dies because you didn't shelter any on the first death and wasted this $13.6 million. Now, you said, where are they headed? Well, next year, 2025, right around the corner, it's going to be $13.9 million. Call it $13,910. Call it $13.9 million each per person. Oh, good. Heading in the right direction. Even more we can leave without paying a federal death tax. Now, the concern in the election, I think, that needs to be factored into our decisions now going forward is, we're not entirely sure, like we were before, that exemption come 2026, January 1, is going to drop down to $5,490,000. Huge drop, right? Indexed for inflation, which we peg at about $7 million. That's still out there. That means that is going to happen unless the government can act to stop it from happening. Okay? That's still a big if. I mean, it did seem more like a mandate before because, I thought that's what it was, but it looks like the majority in the House is going to be, razor thin.
Sure.
I mean, we're looking at like one vote. So is it going to happen? We don't know. I think we have to keep an eye on it, but you have to know that unless they actually get together and act, and the government over the past 8 years has not been good at acting. So I'm not sure it will or will not happen, but I think with the election, you have a better shot at that not coming down to 7 than you did before. So keep that in mind. However, as a separate matter, some of you listeners, not all, have to be more concerned with the state estate tax, right? We have it in Maine. We have it in Connecticut. We have it in New York. We have it in Massachusetts. We don't have it in New Hampshire, so flock there. No estate tax at the state level. But otherwise, the state estate tax exemptions are low. And here in Massachusetts, it's only $2 million per person, and there could be an estate tax. So I think you need to know that those are kind of like, they're not going anywhere anytime soon. There's nothing on the horizon for the state levels, at least here around New England. So bear that in mind depending on where you live.
Talking with Todd Lutsky from the law firm of Cushing and Dole, and if you've got a question to ask Todd, this is your chance to do so live on air right now. Studio lines still have some room on them at 888-205-2263. That number is 888-205-2263. Remember, it's first come, first serve. We're going to take a quick break here, but when we come back, it's right to your questions with Todd. 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Again, we've got Todd Lutsky here. If you've got a question for him, you can call the studio at 888-205-2263. Todd, we got one for you here. Hector in Taunton, you are on with Todd Lutsky. What's your question for him?
Yeah, my mom has a three-family, and she's in the nursing home. She's been there for 5 years, 6 years, and we did she's on Mass Health.
Okay.
We did the Mass Health application this year, and they're saying that she can't deduct the property taxes, the insurance, and the water bill from her portion of the Mass Health payment. So my question is, who's responsible to make those payments?
Well,
on her house.
Yeah, I think first and foremost, is the house still in her name?
Well, yeah, life estate. Yeah, the house is. She's got the house in the life estate, and then my brother and I inherit a remainder after she passed.
Oh, so it's in a life estate arrangement. So what that means for everybody is that she transferred this three-family home, of which she lived in one, and so she reserved the right to live there. When you reserve this little life estate nugget, it's a nugget of ownership that gives you not only the right to live there, but also the right to pay all the bills and the right to collect all the income. Okay, so I assume as part of her patient pay amount, right, they're saying to you, you're on Medicaid because the house is now non-countable, one, because it's your primary residence, and two, maybe because you're renting it. But the rent belongs to her, and so that goes to the nursing home as her part of her patient pay amount. Now, the rule is that the net rent goes to her for her patient pay amount. She is entitled to use the rent to pay these bills on the house, at least as it relates to the rental portion, okay? At least as it relates to the rental portion of the house, which would be 2/3 of the house. So you should be able to argue that 2/3 of those bills at a bare minimum are paid to offset the rent. And then whatever the net rent is goes to the nursing home as part of the patient pay amount. Arguably the portion that, and she still is the owner, but arguably the portion that is her primary residence, they'll say, look, kids, technically the house is non-countable, but you're on Medicaid. You don't really have a lot of spare money. So you kids may need to pay for the, maintenance, upkeep, taxes, bills for 1/3. But I think you could easily argue that 2/3 offsets the rent and you have a lower net rent argument. But you're going to have to go to them and you're going to have to explain this to them. And that's the stuff that, that usually elder law lawyers help with when you're going through the Medicaid application process. But I get this. This is your renewal every year. So I'm surprised after 6 years that they're suddenly bringing this up. Why would it be any different than the last 5 years? I don't know. But I hope that helps a little. Folks, this obviously that's just one of the problems that exist out there when you're doing planning. In this case, this was just life estate planning. The new guide for the month that I want to have you pay attention to is a tale of two objectives: reducing estate taxes and, like Hector's situation, protecting these assets from the nursing home. So some folks want to just learn about hey, I don't care about the nursing homes, but this guide explains the revocable trust. It explains the marital share, the remainder share, and how they work to shelter taxes on the first death from both federal and a state perspective. And it explains the operation of the trust. So if you want to just learn how to reduce your taxes and avoid probate, the guide's for you. If you want to add nursing home protection to that equation, well, this guide's for you too, because there's a separate section that runs an example and it calculates the tax for you. You can put your own numbers in, and it shows you how to shelter assets from estate taxes with a marital share and a remainder share that are a little different than the revocable trust. So it reduces the estate tax and at the same time provides protection from the nursing home going forward. So either way, folks, this guide might be for you. It's new for the month, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another one for you here. Let's go to Catherine in Boston. Catherine, what is your question for Todd?
Yes, I had a sister that passed away, and she had a realty trust.
Oh.
An irrevocable realty trust. And I am the beneficiary on all of her retirement accounts. And my question is, can I put off doing the RMD on those accounts until next year? Because somebody said that the new Secure Act allows you to delay taking the RMDs.
So that is the Secure Act is a complicated animal like anything dealing with IRAs. I can tell you what I do know about it is that, you are allowed, you're actually, as a sibling, you're one of the exceptions. They call them, you're a special designated beneficiary, not just a regular designated beneficiary, for lack of a better term. Meaning you're one of the few people who are, if you're within 10 years of age of the participant, you're allowed to actually take out the asset over your life expectancy. And that's a benefit because if it was a regular designated beneficiary, right, a plain old designated beneficiary, then you have to, like a child, let's say, then you would have to take it out over 10 years, which could cause it to come out faster than it otherwise would. So for you, you get to take it out over your life expectancy. Now, how old are you?
I'm the same age.
Which I don't know how old that is.
77.
77?
Yes.
Yes, so you get to take it out over a 77-year-old life expectancy because, again, you're a special designated beneficiary. Now, the question is, do you have to take it out this year or next year? I think you have to look and see, did she already make her required minimum distribution this year? I mean, if she did, then there was a distribution this year, and you must start taking. Now, remember, next year is only 30 days away. So next year is right around the corner. So you just need to find out for sure, and I don't know that I have that answer, whether you have to take one this year or take it next year. For sure, you have to take it next year. Okay, I just don't know if you need to take it this year or not without actually going and reading that Secure Act. But if you've got a financial advisor, they might know. Your accountant might know. Just trying to give you some folks to check with on that. My bigger question that you didn't ask was, you're the designated beneficiary on that realty trust, you said?
I'm not.
On the realty trust, you're not?
I'm on all of her.
No, but I'm asking about the realty trust.
Unfortunately, she changed that as the last few weeks of her life, and she gave me her home.
Oh, wasn't the home in the realty trust?
The home is in the realty trust, but I had not been in the realty trust to receive the home.
Oh,
that's another huge problem.
Yeah, that's a big problem. So whoever's listed as the designated beneficiary on that account is going to be on that realty trust is really who's entitled to that home. So, yeah, check into that and see if you can get that squared away. Lots going on this case. Great question, Catherine. Thank you. And I think we'll wrap it up.
Mr. Lutsky, thank you so much for your time today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.